Hello, everyone, and thank you for joining us for today's session, Myth-Busting Barriers to Achieving Contingent Workforce Diversity. For this session, Ceipal is joined by Dawn Sealer-Nixon, Diversity and Inclusion Partner at Ford Harrison, and James Lucier, Executive Vice President of ProcureWise. But before we launch into today's session, there are a few housekeeping items to cover. First, each session will be recorded and available on demand through Ceipal's website. A follow-up email will be sent shortly to all registrants with the recordings and all relevant materials. Second, we will have a Q&A session following the discussion. All participants have entered the session muted, so please enter your questions in the Q&A or session chat on the right-hand menu, and we'll address them at the end of the panel. And finally, we are on a strict schedule today. To save time for our Q&A period, we will give a 5-minute warning to the speakers. After the 5-minute warning, the speaker will conclude the conversation and we will open up for Q&A. Please note that this session will end promptly at the scheduled time. At that point, we encourage you to visit our agenda tab and explore other topics and speakers in the 4 different tracks. If you do not visit the agenda tab, you will automatically be redirected into the next session on this track. And that's it. And now it's my pleasure to introduce our speakers for today. Dawn has spent 2 decades partnering with her clients to help guide and direct their employment decisions to avoid the time and expense of litigation by creating and executing effective strategies to defend them through trial should the need arise. Dawn uses her in-depth knowledge and expertise to ensure that clients exceed their diversity, equity, and inclusion goals. We also have James Lucier, Executive Vice President of ProcureWise, who will be moderating this session. Jim is responsible for executing go-to-market strategies, building client-driven growth, and driving the success of ProcureWise. Thank you so much for joining. James, over to you.
Thank you, Spring. And hello, Dawn.
Hi, it's great to be here. Thank you.
Oh, great to have you. Thank you so much. As we get started, I just want to let the audience know that we're not going to make a case for diversity, equity, and inclusion in the workforce or the contingent workforce here. And we expect that if you've joined us, that's a case that you've already made. And whether it's a business case, a social case, or a combination of both and or something else that you've included. Today, what we're going to do is explore some concepts and particularly what may be some myths and misconceptions really about kind of moving from or starting with discrimination and moving to things that you can do, all of us can do throughout the ecosystem to build workforce diversity. So, Dawn, I'm just going to kind of go straight into some questions with you, if you don't mind.
Sure.
Yeah, like I mentioned, I think maybe the best place to start is to get a basic understanding of some concepts with the audience as we begin our discussion. So let's talk about the EEOC and who we know enforces federal laws prohibiting discrimination. What type of employment discrimination are we talking about that the EEOC addresses?
Yeah, so the EEOC is obviously the Equal Employment Opportunity Commission, and it's the federal body that governs, discrimination under the law. There's many laws that are enforced by the EEOC, including, discrimination, harassment, retaliation, things of that nature. So the EEOC laws basically say that it's illegal to discriminate against someone, meaning an applicant or an employee, because of that person's protected characteristic or trait that they might have. And those protected characteristics, is what we call them, include race and color, religion, sex. And when I say sex, I mean not just only your gender, but your gender identity, sexual orientation, even pregnancy. Also, the EEOC laws protect against national origin discrimination, age discrimination, meaning protecting individuals who are 40 and older. It protects against disability discrimination and also against genetic information discrimination. So there's a myriad of protected categories that fall under the ambit of the EEOC's protection.
And so what would be some examples, forms that discrimination might take, because within our audience, we have staffing firms and managed service providers and corporate professionals from HR and talent acquisition, procurement and sourcing. And I think they probably wonder, how does this affect me? Where, could I maybe make a mistake, or where do I have to make sure that I'm following the law?
Yeah, that's a great question. So discrimination can show up in a number of ways in the workplace. Recruiting is one example of where discrimination might show up. So for example, it's illegal for an employer to publish a job advertisement that shows a preference for or might discourage a group of individuals from applying because of their protected category, which are those categories we just talked about just a minute ago. It's also discriminatory for an individual organization to recruit for a particular category. I know that you've probably seen, over the past couple of years, people setting goals for particular groups of individuals to be represented in their organization. Well, it's discriminatory under the EEO laws for organizations to recruit for those particular categories. So you can't base your hiring decision on assumptions or statements about a person's protected category. Discrimination also shows up when you make decisions about job assignments or promotions. If you're doing that based on their protected category or protected trait, then that could be discrimination. So for example, if you have a pregnant employee and you decide that you're not going to select that person for a job assignment because there's a lot of travel involved with that job assignment, that could be discriminatory. Or if you give preference, for example, to a Hispanic employee when you're making a shift assignment over a Caucasian employee, that could be illegal discrimination. So there's lots of types of discrimination that could be illegal under the laws. I mean, obviously some of the ones that are clearer when you're trying to terminate someone, or you're paying somebody wages that are different than someone else based on their race. And so an example that I try to give is if you have two employees who both are engaging in theft of time, for example, you can't treat one employee differently because that employee is disabled and you want to keep disabled employees in your workplace because you want to encourage diversity. You have to treat both of those individuals the same so that you can have a defense to a claim if a claim is brought under one of these EEO laws.
Thank you. So that's interesting. You actually mentioned something I think comes up a lot for our audience, that, of course, knowing that, well, you can't make, we'll say, gender or race a part of the hiring criteria for a specific job. But what about if you're developing a pool of candidates? You mentioned sourcing. Right. So what if you're just developing a pool of candidates and it's not for a specific job? Can you speak to that some?
Yeah, definitely. So I've had some experience with helping employers to develop what we call diverse slates. And so that's that pool of candidates that you're talking about. And there's a lot of research around having specific groups of individuals within that pool. It's more likely that you're going to be able to hire a diverse individual from that pool if you have two or more individuals from that diverse category. And so you can look at bringing in an influx of diverse individuals for the pool because you're not making the selection decision there. So the EEOC laws prohibit discrimination in the hiring or firing of an individual, not in the creation of the pool. And so that's where we can really make headway as it relates to diversity, equity, and inclusion, by having this diverse pool or diverse slate, as we call them. And then from those slates, then making decisions based on who's the best person for the job.
Thank you. So when we talk about the EEOC laws, as you have, who do they pertain to? And how does the EEOC enforce these laws?
Yeah, so, I mean, it really pertains to all employers. I mean, there's a lot of information in each one of these laws about who's covered and who's not covered. So most employers with at least 15 employees are covered by most of the EEOC laws that we're going to see, like Title VII and those types of laws that protects against discrimination based on those categories we were talking about before. In terms of age discrimination, you've got to have 20 or more employees. So you can see there's nuances in each of the laws as it relates to the number of employees and what's protected. But what happens oftentimes that we see is that employers forget about some of the laws where there's no limitations, like a statute called 42 USC section 1981, which prohibits discrimination on the basis of race or national origin or religion. And under that section 1981, there's no limit on how many employees a company must have in order to be protected under that or to have to comply with that. And so it really opens up companies in the US to liability under multiple laws. And there's going to be different thresholds for different laws. So for example, many people have heard of the Family Medical Leave Act that protects jobs for individuals who need to go out on medical leave. Well, it requires an employer to have 50 or more employees to be covered. And so there's different requirements that you need to know of for federal laws. And then you can layer on top of the federal laws, the state and local laws, depending on where you are located, so that you would need to be aware of what those are as well. So I try to tell employers, don't get so focused on if you're covered under a particular law. Focus on the fact of treating everyone equally and not in a discriminatory manner.
Well, that certainly sounds like sage advice, right? For sure. So we talked about that that there are different thresholds, I guess, where various parts of laws may apply or how the law may apply, and they apply to all employers. Does that mean staffing firms too?
Yep, it means staffing firms too. I mean, staffing firms are employers, right? You have employees, and they're subject to many of the very same laws that employers are. But there are additional things that we need to consider when we're talking about staffing firms that provide workers to employers, right? And that's something that we'll probably want to talk about, as well.
So when we're talking about joint employment or co-employment,
yeah.
Could you get into that for us a little bit, please?
Yeah, definitely. That's exactly what I was talking about, right? And so there's historically been an inherent tension between employers and the contingent workforce agencies, especially as it relates to who's considered an actual employer, and what you need to do in that employment relationship. And I think that those are key factors that we need to recognize on both sides as, we move down this path, because we're becoming more and more integrated with one another. And that's something that the courts are looking at as well.
So, I've been in the staffing industry for almost 20 years, and it's interesting because we're still talking about joint employment and co-employment. And I still hear things sometimes about, well, if a person, carries a different color lunchbox or eats in a different cafeteria or has a different kind of badge or something like that, we can somehow avoid co-employment or joint employment. Is that true?
Yeah, there's a lot of misconceptions or arguments about what you can do to avoid, joint employment. Some people think, it has to be less than a year the person is employed for me to avoid joint employment. And it really depends on who you ask, right? And I say who you ask, meaning, are you talking about the Labor Department? Are you talking about the National Labor Relations Board that deals with unions? Are you talking about the EEOC that we've been talking about? Because there are varying tests that are used to determine whether two or more companies can share this joint liability. But, in general, I think that we're moving more and more to the center where employers and staffing agencies are going to be considered co or joint employers. I will tell you that, courts have considered, lots of things, in making their determination, right? I mean, they consider who's got the right to select the worker, who's responsible for the payment of the worker, who can hire and fire the person from the position, who's responsible for directing their work, and lots of other factors are considered. It's very, very complicated. But one of the main threads through all of these analysis focuses on how much control the potential joint employer exerts over the individual worker, or how much they have the right to exert over the individual worker. And what we've seen is it's so difficult to prove as an employer that you don't control a contingent worker who's working side by side, under the same watchful eye of the employer's management team, using the employer's tools, following the employer's rules. So I mean, that's where the tension comes in, and it's very difficult to make the argument that that individual is not an employee of the employer and not an employee of the staffing company. And so both sides really need to be very careful about how they're treating the workers, because their treatment can be inferred on the other party.
Well, let's explore that a little further. I mean, what does that mean exactly? We were talking about discrimination and federal laws around discrimination and the EEOC. So as a staffing firm, I have to be worried about what's happening with my workers at the work site. And as the employer, the client of the staffing firm, I have to worry about the staffing firm's hiring practices.
Yep, absolutely. Absolutely. So if you're a staffing firm, you're putting your employees, the workers, into a different environment, and you're responsible under the law to protect those workers. So if those workers are being harassed or discriminated against or treated differently by the employer that we're replacing the workers, then you may be responsible for that. And so, you really have to keep an eye on both sides in terms of what's happening with the employees. So from the employer's perspective, is the staffing company providing benefits? Is the staffing company paying the individuals the way that they should be paying them? That could come back to the employer potentially if they're deemed a joint employer. So you really do need to collaborate on both sides, to ensure that the employees are being treated the way that they should be treated by both parties.
So we've been talking about discrimination laws as they apply to employers, and including staffing firms as employers. But our larger discussion is really framed around building a more diverse, equitable, and inclusive workforce. When we talk about the contingent workforce, while if we take it out of the context exactly, I think of maybe the federal discrimination laws. Is there any application of the law that suggests that that really applies to the contingent workforce and that relationship between the staffing firm and the client to build a more diverse, equitable, and contingent workforce? Companies are wanting to do that, right? The whole ecosystem is working together to do that. Some are doing it for a business case. Others are doing it for social reasons. It's a mandate, and some companies want to look at their workforce holistically, and their contingent workforce is a very large part of it. But is there any law providing for that?
Yeah, I mean, there's really no law that's providing for capturing demographic data from the contingent workforce. We talked a little bit, as we were coming on about, the EEO1 component of providing information and providing data on your workers. And that's something that both the contingent workforce, the staffing companies, the PEOs have to do just as well as the employers, have to do. And so
as the direct employer.
As the direct employer. Yes, exactly. Mm-hmm. I mean, capturing that information and providing that information to the federal government is a mandate. And that demographic information can include race and ethnicity, sex, as well as, their job categories that the individuals are working in. And so I think that both sides need to give, very careful thought to ensuring that we are capturing some of this information and sharing it with one another so that we can determine whether or not we're truly becoming diverse workforces, right? I mean, as you said, there's so many contingent workers that are staffing up for the employers because they don't have the people who they need, especially in the environment that we're in today. And so not counting those people or not looking at the demographics of those individuals who are being influxed into the workplace is really doing a disservice in some way. And so we really do need to find a way to capture that data, share that data with one another. I know that many employers use the methods that the EEOC has set out to capture much information when it's not self-reported, right? I mean, self-identification is the preferred method, of reporting that.
Let me mention a little bit about that relative to the contingent workforce. Because, I had a session earlier this morning with the CEO for Guiding Global, and we talked about how enterprises, particular Fortune 500, Fortune 1000, workforce diversity has been on their radar for a while. And they've done a lot for workforce diversity when it comes to their employees, but not necessarily, more than within the last couple of years for their contingent workforce. Certainly that's, come much more to the forefront when we talk about the contingent workforce. We really all have to work together. Again, I mentioned, some of the groups in the audience today, right? They're the end clients, the staffing firms, the MSPs that are an intermediary between them. And I do believe that the whole ecosystem is really starting to work together, but, and for good reasons. You mentioned some of them. I mean, some of them are business reasons that, there's a lot of research to point to. Some are just around the war for talent, and there's untapped talent, right? By opening the gate a little wider and just bringing more people in. And there are social reasons, and it's just simply the right thing to do. But regardless of the reason, I do believe that the whole ecosystem is starting to work together, but it's hard for them to find a starting point. So about a year and 4 months or so ago, Staffing Industry Analysts, really the biggest advisory firm in our industry, did some research, published this research, and said that really the number one obstacle to, or one of the top barriers to developing workforce diversity in the contingent workforce was a lack of diversity data. And so that, that's kind of bringing in what you're talking about with the EEO-1. I know the new EEO-1 reporting is about to open again soon, but let's talk about the EEO-1 right now. As you mentioned, there's a lot of workforce demographics that are captured on the EEO-1 report. And essentially every employer has to report information about their direct workforce, and that includes staffing firms as employers, right? And you touched on some of the types of information. Let's talk about how that's collected. So one way is there's voluntary self-reporting, and there's guidance about that. And I think beyond that, there's sort of a misconception about, is that it? I mean, is that where we need to stop, where we're supposed to stop, or is there something else that we should do and we're even instructed to do?
Yeah, and the EEOC gives really good guidance, and we can drop some links in for the people, later on about the EEOC's instructions that are there. I mean, their preferred method is what you said, is self-identification under federal and state law is the preferred method, but that doesn't always work well under certain circumstances, especially with the contingent workforce. And so the EEOC's really expanded that and indicated that visual identification is permissible, but that's often been very difficult. And it's been made even more difficult now because of remote work, where some employees never come to the workplace. And I was just having a conversation with another client where some employees never turn their cameras on, so you can't visibly look and tell who someone is or what category that they might fit within. And then, so the EEOC has also indicated that employees can start begin using current employment records to identify individuals, or what they call reliable information, like in cases of gender categorization. I mean, that's a new area that's captured on the EEO-1. And the EEO has said that you can use the employee's own stated pronouns. So I'm sure you've seen, emails where people have their pronouns at the bottom of their email trail, and you can use that to determine what the employee's gender is. And if there's not a box to identify what that is, then there's a section in the EEO-1, sort of a catch-all at the end, where you can put that information in and how you're capturing it for the form. So, I mean, there are multiple avenues to really generate the required information that's there. I mean, but we need, one thing I was thinking about is we really need to get to a space in our workplaces where there is psychological safety around providing this valuable information to us. And I know that you all are working on, really innovative technology that will help with that. And so, that would be a good area too for us to look at.
Right. Well, what we see, I mean, I've, read statistics from the EEOC reporting that says less than half of people self-report. Right. You can look at, many large companies now are publishing their EEO-1 data in annual diversity reports, and they typically will add the metric in there of what percentage of their employee population self-reported, and that's generally below 50%. I mean, one of the highest I think I've seen is about 65, 68%. Yeah. And anecdotally, I've heard really throughout the contingent workforce space is that when that methodology is being applied, where either the end client or the MSP is directly surveying through some type of communication tool, the contingent workforce, it's often under 20%, maybe 10 to 15%. And there's a lot of fear around that. I can't characterize it all as that someone's unwilling to disclose this information because of fear, but I think we could generally say that's probably the case.
Yeah, I mean, I think that's true. I mean, I've done enough focus groups and surveys to know that people are simply fearful of providing the information because of the fact they think that something's going to happen to them now that someone knows, or that someone would be able to figure out their answers to a survey, for example. I mean, I do a lot of diversity surveys, and so when we ask for demographic information, it's to use that information in the aggregate as opposed to try to drill down and figure out who said what. But the responses that we've gotten over people that don't provide that demographic data is it's for fear that they're going to be found out, that the answer is going to be tied to them, or that demographic information is going to be used in some way against them so that they won't get opportunities that they otherwise would have received had you not known who they are or what categories that they fit within. Or people are fearful because they're fearful that you might just put them in a box, right? Because we all make these split decisions about individuals based on, the category we think that they fit within when we meet them. And so there is a lot of fear. I mean, that's true. There's a lot of fear around it. And so that's why we see these low numbers of self-reporting.
Mm-hmm. Yeah, absolutely. So in a perfect world, we'd have all the self-reporting information, and somehow it would flow easily in the contingent workforce from the staffing supplier maybe to the end client, so that together all the parties, could work in a spirit of cooperation for the good intent of building a more diverse, equitable, and inclusive workforce. And so right now, practically speaking, this is what's happening. End clients or their MSPs are asking staffing firms to present some information about maybe their workforce on assignment, or possibly even candidates that have been submitted. And I think there's a lot of question for maybe all the parties. Is it okay to share that information? And if it is, how should you share it, and what should you be cautious of, and what do you have to maintain, and things like that?
Yeah, I mean, it is okay to share the data. I mean, I can tell you that organizations are fearful, rightly so, about and very precautious about sharing their data with other people, because data is one way that an individual can prove a case of discrimination, right? And the courts have said that that's true. And so people are afraid of providing, less than aggregate data, for fear that that information could be used against them, even though they're taking great steps and leaps to ensure that their workforce is diverse. And so, in sharing this information, I do think that it would be helpful for the contingent workforce to share the information or data on the workers that they are placing with the employers, for a number of reasons, because it's only going to help out the diversity metrics and statistics of the employer, but it's also going to show that the contingent workforce is diverse in and of itself, right? And that you can go to this particular organization to get a diverse group of individuals within your workplace. And so I think what's happened, though, oftentimes is that there's this, I'm going to hold my data here and you hold your data over there, and the two are not going to meet. But like you said, a lot of employers are asking for this information. They've asked it of our firm. They want to know who's working on their, not only who's on the team, but who's actually working on their cases. And so we're getting more and more requests for the drill down data on some of the demographics related to particular projects or cases that we're handling. But so the same precautions, if you're going to share information, I think that the same precautions that you would follow as an employer for your own demographic data should be taken into account when you're sharing that information, between, the contingent workers and the actual employer. And meaning you need to keep that information as confidential as possible. Try to share the data in an aggregate and not specific down to each individual, so that there's no way to really determine who each individual, that is listed on the survey is, right? So you don't want a party to be able to drill down and say, this is Sam who worked in our, housekeeping department. That's not what we want. We need more high-level information. But when there is a need for more granular information, if you're trying to, let's say you're trying to improve diversity in one particular department and you need more granular information about that department, I think to the greatest extent possible, you should work with your legal departments or work with an attorney to find the best way to share that information and try to cloak that information as much as possible with an attorney-client privilege. I share that information in some kind of encrypted method where you've got a password and where, it's not something that everybody would be able to see, and then only share it with a limited group of individuals. And that's also going to help maintain confidentiality as well as help maintaining any privilege that you might have relative to the compilation of the information that's shared with one another.
So I've been taking notes as you've been talking, right? And I heard what it sounds like, fear with individuals of self-reporting, keeping self-reporting information, down, right? So that there's, maybe very incomplete information about the workforce, might be a very small part of the workforce. So that makes it really difficult to take that information and do anything useful with it. Then I've heard, and frankly, I hadn't heard of this risk that you just mentioned before about maybe some type of potential liability for staffing firms that are trying to provide complete information in the aggregate, but as it turns out, the information's incomplete simply because they're not getting all the self-reported information, right?
Right.
So a potential risk there. And so you can see those couple of things just right there are really kind of standing in the way for companies large employers, meaning companies also that have large contingent workforces, that this is limiting the opportunity to really develop a more diverse contingent workforce, which means it's limiting the opportunity for workers as well. And if I think of a couple more things that you mentioned, when you start getting asked about small numbers of workers, it's much more likely that you can take those demographics and just attribute it to a specific worker, even if they're not named, right? So I'm guessing that's a risk. And then if we're talking about large numbers of workers, where in some contingent workforce programs, it's thousands to tens of thousands, and you're just collecting this information by email or in some other way, it's impossible. To be able to report on it, like you mentioned before, maybe there's a gap we need to identify in a specific area. Maybe it's a location, or maybe it's a specific skill area, or department, or something like that. So, because of that, and because of this interest, and really a mandate with some companies, large companies, to develop a more diverse contingent workforce, there's been emergence of technology that uses artificial intelligence and algorithms that are trained with on the science of neurolinguistics to be able to take information as little as a first and last name to make gender inferences or inferences about gender and ethnic demographics within the workforce as an aggregate. But there's apprehension there, I'll tell you as well, right? I think whenever we talk about diversity and equity inclusion, there's always some kind of fear. Am I going to do the wrong thing, say the wrong thing? Can I actually do this or not, right? So let's talk about that with this type of technology, using a first and a last name. I think everybody has heard about, PII, or personally identifiable information. So what about that? First and a last name where does that fit in terms of PII?
Yeah, I mean, there's PII is a big area, and you're absolutely right that people are, I think they get so fearful that they don't want to do anything, right? But this PII is information. When you use it alone or with other relevant data, you can identify someone. So it really is that drill down kind of issue that we were talking about. And there's two types of PII. It's sensitive and non-sensitive PII. And sensitive PII can include things like your full name and your social security number, all those things that you're not supposed to give to anybody, right? Your driver's license number, your financial information, medical records, even. And then the non-sensitive PII, like you're talking about, is stuff that's easily accessible from public records. Your name, your zip code, your race, sometimes your gender, even your date of birth probably could be accessible on some public records if you know where to look for that. Your address, those types of things. I think the problem comes when you use this non-sensitive PII and you combine it with other non-sensitive PII, then it becomes sensitive PII, right? So, and I know that's probably a tongue twister, but so for example, if you combine someone's race with their date of birth, you are likely going to be able to figure out who the individual is, that's listed on your chart or on your demographics. And then once that information is known, it's so easy to go back, figure out who the person is, like I said, and potentially use that information to uncover additional facts about the individual, or maybe you use that information to select or not select that person for a job or an opportunity, or give that person a raise. And then it sort of comes all full circle to where we started at, from the beginning, in terms of someone being discriminated against in the workplace based on a protected characteristic or trait. And so we have to be very careful about, this sensitive and non-sensitive PII and the way that we use it, where we store it, how much information that we obtain, from individuals, and try to protect that confidentiality as much as possible so that there's no way to drill down. And so there's no way to attribute some kind of discrimination to your management team or to your leaders or someone because they didn't know. that person's characteristic or trait. There wouldn't be a reason for them to know it or how to get that information. So I think that's sort of where we need to go with that. And what I try to tell organizations is to keep that information on a need to know basis only, right? Keep it within one department so that it doesn't reach, for example, the hiring manager. So the hiring manager doesn't know what race, gender, ethnicity an individual might be when they're making that selection decision, for example. And so, there are a lot of things to consider, when you're talking about gathering information, especially as it relates to demographic data.
Right. So, but to assume we're taking maybe just a first and a last name of non-sensitive information and using artificial intelligence to infer some demographics at an aggregate level, no individual level. Jim's is not Jim this and Dawn that or anything else like that, right? It sounds like that can be really useful in terms of getting some clear insight into again at an aggregate level the demographics of the contingent workforce, because it's so difficult to get this information any other way. But what I want to make sure that I've heard you say that we just kind of maintain with the audience, because this type of technology is so new, that it's really important that we don't attach other non-sensitive information to, because things could change. Right now, it's all sensitive because of what's been attached. So we keep it simple with things like first and last name. It's also important that the data is not shared with a large group.
Right.
And that if you're using a technology or a platform or something like that, that of course there are security measures around privacy and data security and encryption and things. And I guess from a reporting perspective, looking at things in the aggregate, and again, not on an individual basis. And what we're seeing that companies are really looking for this, kind of bring us back to where we started the conversation, is where can they find a starting point, right? Like you're running the HR group, you're managing the contingent workforce, you're sourcing for talent. You have some role in helping build a more diverse, equitable, and inclusive workforce, including the contingent workforce. But you sort of don't know where your gaps are. And if you don't know where your gaps are, it's hard to find a place to start. And to do, for instance, one of the things you said could be maybe the next point in how can we open the door wider, open the gate wider, bring in more diverse talent, slate more diverse candidates and things like that. There has to be some kind of starting point, right? How do you solve the problem of diversity if you can't measure and track it in some way that isn't intrusive and, that you're using information in a legal way for legitimate business purposes, right? So yeah. I guess, we're up. I'm sorry. It's always interesting to talk with you, Dawn, and I'm sure that our audience really learned a lot, and we're so grateful for you to be here. And I just want to mention to everybody, Dawn's a great resource. I think we put her LinkedIn link to her profile. Just you can already tell, if you need help in this area, please reach out to her. Take a look at the Ford Harrison site, and I'll tell you, I'm personally signed up for some of the resources that they make available to people to just give your name. I mean, the information comes every day, and it's really valuable and useful and handy and put together really well. So thank you, Dawn. Thank you, Ford Harrison. Spring?
Dawn, thank you so much. It was wonderful to have you with us again today. Your insights are tremendously valuable. Jim, thank you so much as well. And to our audience, thanks so much for being here. As a reminder, please explore our agenda tab at the top. Otherwise, you will be rolled right into our next session coming up shortly. Thank you both again.
Okay. Thank you. Thanks, Dawn.
Thank you.